an order of stay. This order of stay we are seeking, Your Honor, is akin to the orders granted by the Supreme Court of Appeal, the famous Rule 52B. And therefore, Your Honor, what we need to satisfy you with is whether or not there is a justification for that stay. It has been urged before Your Honor that the chargeship borders between violation of a fundamental rights. Therefore, the question to answer is whether or not, if that charge is read and plea taken by the suspect, whether it will amount at the fullness of time to a violation. Whilst answering that test, Your Honor, we shall be answering the question of rendering the intended constitutional petition nugatory. If she takes plea and then we move tomorrow to the High Court or today to the High Court, will it be an academic exercise? Will it amount to an academic exercise? That is a test that will the court ought to apply. Number two, Your Honor, is a test that, granted the magnitude of the petition that we intend to file and the consequences that will befall the accused person if she were to be found to be guilty, would eventually culminate to a fine of 5,000 or 6 months imprisonment. That is to say, therefore, the violation may be much more surmounting than the consequences that will befall her. The other test is whether there shall be any person who shall suffer prejudice. And the state being the complainant, and in the absence of a private citizen who would fall in the category of a victim, the balance tilts in our favor. That there is no complete natural complainant, natural person, saying that Honorable Jayne Kihara has wronged me in this way, and therefore the delay will occasion injustice to that particular person. Because this is an alleged offense against public order. The other justification, Your Honor, is that we need the High Court to expound on Section 8. And this is a justification, Your Honor, that Section 8 cannot limit you to the only rights under Article 25, A and B. Because A and B speaks about torture and being subjected to slavery and servitude. Yet today, or even when we appear before you, you exercised a right under Article 49. Article 49 is not what is encompassed under Section 8. Therefore, to say that Section 8 is constitutional would therefore mean that you today do not even have the ability of exercising the rights under Article 49. Because Article 49 is not covered under Section 8. It therefore means that all these courts have been acting unconstitutionally. Number two, Your Honor, while Article 25 speaks about the non-derogable rights, among them Article 50, the fair hearing is not encompassed, is not protected under Section 8. Does it therefore mean that this court will not, or any other magistrate court, cannot exercise that right under Article 50? Because Section 8 limits. The other justification, Your Honor, is that this court is enjoined by Article 10 to enforce the Bill of Rights. Article 10, which binds all state organs, state actors, state, whenever any of them is interpreting the law or applying the law, is not covered under Section 8. So the question will be put into the High Court is, can Article 10 give and Section 8 take away? So those are very fundamental issues that will settle the law on the ability of the magistrates court to enforce the Bill of Rights. Because Article 10, Your Honor, provides in a blanket way that you must enforce a Bill of Rights. And when enforcing them is protecting them from denial, from infringement, from violation, or even from a threat. And therefore, to protect that foreseeable threat, the application for stay is justifiable. And it's not just justifiable, it's justicious. And Section 8, Your Honor, does not bar you from applying the doctrine of proportionality while granting this stay, insofar as the rights that we are seeking to protect are in issue. So, Your Honor, there is all reason to justify that one, the accused persons before you, or the suspect before you, is a state officer. What she's alleged to have violated relates to her constituency. There cannot be representation without speaking. That is, there cannot be representation without the right of self-expression or freedom of expression. The state says we have violated it. How then will representation ensue? So, by the stroke of the pen, Your Honor, it can, or by the action of the Odpp exercising their power under Article 157, can actually amount to a limitation of a right, and that is what you want to go and argue in the High Court. And we are not offended by your findings. We are offended by the legislation. That the legislation is purportedly limiting you to protect a right. 14 days, Your Honor, is not so much to ask. Honorable Jayne Kihara will still be within the jurisdiction of this court. She will be available and she will be subject to you. So we can have a mention in 14 days to confirm the outcome of our proposed petition. If this, Your Honor, is not going to be done, you'll see a litany of members of parliament appearing before you. Even myself, I may appear before you, especially when I say one term. I'll be next. Especially when I propose a doctrine of one term, which you propose out there. So, Your Honor, or the member of parliament for Natanga. So, Your Honor, we urge you to grant us this stay, subject our arguments to those three tests: who suffers prejudice, whether the proceedings will be rendered nugatory, whether they will amount to academic exercise, and whether it is justicious for us to move to the High Court and check the possibility of Article 10 giving and Section 8 of the Magistrates Court taking. Thank you, Honor.
You know, we might be saying all that and the state is conceding.
We will come the concession.
I have a few comments. You know, as you have rightly stated in your ruling, the only issue for consideration here would be whether the charge sheet that we presented before you was proper under Section 134 of the CPC, whether it discloses a known or existing offense, and whether the suspect hearing will be able to defend herself or rather understand the charge well enough to put in a defense. And those questions have been answered in the affirmative by your ruling. Your Honor has also distinguished what pertains to freedom of expression under Article 33 and whether this court can deal with issues pertaining to limitation of some rights under the Bill of Rights, and as rightly stated by the court, and the authority that the court alluded to, the only violations that this court can entertain in line with Section 8 of the Magistrates Court Act are the ones under Article 25A and B. At this point in time, plea taking may not bar the defense from moving to the High Court for a constitutional interpretation. Decisions of any court higher than this one are binding on this court. I have not heard them indicating to us the prejudice that the suspect will suffer once she takes plea. The office of the DPP will also be bound, is also an office that is bound by decisions of the higher courts. When we were here last before you, the argument by the defense was that the charge sheet presented offended sections of the law. That the court has dealt with. So, Your Honor, it is our submission that nothing bars the suspect from taking plea at this point. They can move to the High Court for interpretation of the section of the articles that they indicate. Once the High Court pronounces itself, then this court will comply with those orders. So at this point in time, the suspect is before court. The court has indicated that the charge sheet is proper. So we oppose the application for deferment of plea. That is all.
I'll ask you, they were given to report on the issue of charges of countries.
I take it that the prosecution has not controverted our arguments. Other than subjecting a question to us that we have not indicated the prejudice she suffers, that is on record. She has not urged you to find that you suffer any prejudice whatsoever. And to the best of my knowledge, is that the office of the Odpp is an independent office. They are bound by the decision of the Supreme Court or Superior Court. Yes, but not their decision to charge, because that is independent under Article 157. What we are asking, Your Honor, is within the provision of the Constitution at 165 clause 3D, that the High Court may have the opportunity of determining whether anything said to be done has been done in accordance with the Constitution. And therefore that's how we shall be invoking the jurisdiction of the High Court. And the same can even be exercised if we were to invoke the supervisory jurisdiction. But we are not asking the High Court to supervise you because you have not made any error. We're not asking the High Court to supervise you. We're asking the opportunity to test whether anything said to be done by the Odpp has been done constitutionally. That's why we're not invoking the supervisory jurisdiction. And as such, our argument, Your Honor, remains